packet from them dated September 15th of 2025. It includes the attending physician's report to the court from, good morning, you're Raul Carreno. And Mr. Carreno's case is set for trial to begin with jury selection next week. Mr. Matuska, Mr. Nichols did mention to me this morning an issue.
It's with scheduling. The DNA was sent out to a private lab, and they were requested a little more like a month or so ahead of time notice, and I only gave them a few weeks, and they said they wouldn't be able to schedule.
Okay.
So I'm asking for a reset for that.
And that's a private, it's not the normal lab that we use?
It's not DPS, it's a private lab that was used to expedite testing in this case.
Okay. Obviously, we need that, I would think. Okay, so what I'm going to do is I'll reset it to the next trial docket. Obviously, at that point, it'll be time probably to get it done. That'll give you plenty of time to get with them now that we know that issue. And so we'll get that taken care of and get it on the next trial docket.
Yes, ma'am.
Okay, thank you. Go back with the bailiff. Is Mr. Samuel here? Oddone Samuel?
I did see.
Oh. Okay, how long, obviously you need some time, Mr. Galmore, but how quickly could you get up to speed on the money laundering?
It wouldn't take me very long to get up to speed on the discovery and watching the videos, but it'd be substantially more difficult to try to track down financial records for Mr. Green while he's incarcerated in the Jefferson County Jail, which is one of the reasons why we're asking for bonds, so that he can assist in that part of his defense.
Your Honor, I would offer this. When interviewed by the law enforcement, the defendant indicated that he had no records that would show the source of the proceeds that were seized.
That you're correct, that's what I see as well, other than maybe one social media post on Instagram.
It appears on the roadside discussions about the sources of money that Mr. Green did not have a lot of answers necessarily, but I would say that on the side of the road, and the question about.
Well, I think they brought him in and Mirandized him, right? Once at the jail, read Miranda warnings, waived his rights, and during the interview, couldn't explain how he obtained it, advised he sold one French bulldog late last year for $1,500, but nothing else. Didn't have a job. One Cash App thing he could show for that one dog. So,
I haven't seen that video
Yeah.
yet. I'm assuming this video recorded is supposed to.
it should be, yeah.
I just haven't had an opportunity to review that video. I do know that there was a car wreck where he received a settlement from that car wreck, so there were some additional funds that weren't discussed. But again, I don't have access to those records as of yet.
Okay. All right, so what I'm going to do is grant the relief requested in 23-1502, set the bond in that case at $35,000. In 24 DCCR 1320, also set the bond at $35,000 in that case. I'm going to order as a condition of both of those cases that Mr. Green remain in Jefferson County, also that he wear a GPS monitoring device at all times, and then we will reset the case for a status at just in normal 30 days or so. Okay?
Would the court believe or think that a curfew would also be appropriate?
He's on probation, so he has a curfew.
All the standard conditions.
All the standard, you're still on probation, so if you make these bonds, all your regular conditions apply, but now there's the GPS monitoring device and a remain in Jefferson County also as a condition of your bond, not just your probation. Okay? All right.
Let's do them and report to police.
Thank you, Judge.
Yes, sir.
Judge, can I approach very briefly on?
Give me just a second. I don't know if I need all that, but that's all his stuff. Yes, sir. On Romeo Johnson?
He doesn't want to make a counter offer.
Okay.
So I was just letting the court know.
All
I
right.
do know, kind of need to know, I guess I'll find out after it's numbered, what case we're going on. Yeah.
Well, let's figure that out. So it's going to get numbered. And so which case would be Mr. Coleman? Which case would the state intend on going on?
The murder judge.
Okay, so 24 DCCR 2419 will get numbered. Thank you. What? Yeah, because I'll number them, and then in a little bit, I might get one of y'all to help me send out the trial order. So yeah, she didn't reset any of those yet. Yes, ma'am, thank you. What you need? Mr. Rojas, you have Christian Kane. Good morning.
He's competent, but we'll do the competency first things.
Thank you. Give me a sec. Good morning. Are you Christian Kane?
Yes, ma'am.
Okay. We're going to lesser.
Yes, Your Honor.
This is cause number 24 DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for competency restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Liberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then at this time, based on the two reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24 DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Not guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that, find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Hey, this get, because obviously got added to the.
See, Marco Gomez, Mr. Rojas.
Judge, I don't know that we need him, Judge. His family's gonna look into hiring him an attorney.
Okay,
Same thing with Mr. Hawkins. Mr. Hawkins' family's already talked to somebody. They're gonna hire him this week, he's been told.
okay. So we'll reset Mr. Gomez, and if you'll make a notation that his family wants to hire attorney. And who was the other one? Mr. Hawkins?
Calvin Hawkins.
We'll reset Mr. Hawkins as well, same notation, please. And, let's see. Lucius LaFleur, Mr. Rojas? Are you working on Hendricks?
Tommy's got it. It's an add-on, so he needs his file to see what make sure the offer is right.
Oh,
But they're all gonna be, everything else should be approved. I'll email the attachment.
thank you.
What happened?
Paperwork I sent by.
You said 30
days in jail.
I don't have that. Let's hold off on that.
I'm okay.
Good morning. Are you Lucius LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LaFleur, in cause number 20-33730, I have a motion to revoke your community supervision. This shows that you were placed on probation November 3rd of 2021 for the third-degree felony offense of theft of material, and that was a 7-year term in prison that was probated for 10 years. Is that correct?
Sure.
And the motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of a Class A misdemeanor assault September 11th of 2023 in Angelina County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the offense of possession of a controlled substance January 23rd of 2024 in Angelina County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department by mail or online for the months of April, May, June, July, August, September, October, November, and December of 2023 and January of 2024. And is that true or not true?
True.
You guys have an agreement, right? Do I need to keep going, Mr. Coleman?
That's what I was looking for. The state will waive the remaining counts.
All right, so stay abandoned 4 through 6. Mr. LaFleur, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
And did you plead true to those counts because they're actually true?
True.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
True.
Yes, it is.
Thank you. And do you fully understand them?
Yes, I did.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. find sufficient evidence to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm trying to print and it's just, I'm going to hand you the trial court certification that shows this was an agreement, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because your probation you've been on it for a while, I'm not sure that you got this when you initially got on probation. But because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.